has advised me we have a quorum, and it being 11 o'clock, I will call the meeting to order. Welcome to meeting number 140 of the Standing Committee on Human Resources, Skills, Social Development, and the Status of Persons with Disabilities. Today's meeting is taking place in a hybrid format. All witnesses have completed a sound test. I would like to remind participants of the following points. Please wait until I recognize you by name before you participate. You have the option to participate in the official language of your choice in the room. Make sure you're on the proper translation channel to have the language of your choice. Those appearing virtually, you can click on the globe icon at the bottom of your surface and choose the language you wish to participate in. If there's an interruption in translation service, please raise your hand. Get my attention. We'll suspend while it is being corrected. Again, please direct all questions through I, the chair. Wait until I recognize you, until we participate. C'est bon, Madame Vien? C'est bon?
Are we ready to go, Ms. Vien? Very well, thank you.
So this morning, I welcome Madame Vien back to committee. And pursuing to order of reference of Wednesday, September 25th, 2024, the committee is resuming its study of Bill C-378, an act amending the Canada Labour Code. We have with us this morning two departmental witnesses. From the Department of Employment and Social Development, Mr. Mohammed Ali, Director, Strategic Policy Analysis, Workforce Information Directorate, and Labor Programs, as well as Ms. D'Angela Hong, Director General, Workplace Directorate, Labor Program. The officials will not be giving an opening statement, so we will be going directly to our standard line of questioning to the witnesses until the committee members exhaust their questions, any questions they may have on to the witnesses. You look like if you have a question, Ms. Gray.
Mr. Chair, if I may, this is just a housekeeping question, if I may, before we start the meeting here. We just almost completed Ms. Chabot's study on seasonal workers, and there was one part of the motion that wasn't fulfilled yet, and that was to invite the Minister of Employment, Workforce Development, and Official Languages. It's actually part of the motion, and that minister hasn't come and spoken yet on that study. So I'm wondering, like we've done with other studies, if we could keep the study open until the minister comes to speak on this. Just so that the clerks didn't move, or so that the analysts didn't move forward, and so that we could just schedule the minister to be here.
Yeah, you are correct, Ms. Gray. The motion was adopted for the minister to be the last witness appearing, and that is being worked at. As you know, there was a change. So the invitation has been extended, and we're setting up the time, but this study motion cannot conclude until the final witness appears, which is the minister, as you correctly pointed out. Madame Chabot.
Thank you for sharing this. I fully agree with the motion, which indeed specified that we would have time with the minister, the interim minister right now. That being said, I take it that this won't prevent the analysts, given that we need to report to the House, this won't prevent the analysts from starting to draw up a text reflecting what we've heard so far from Justice. So, yes, suspension if you wish. We won't be able to wind up that study until we have that last hour. However, from where I come, we hold that it's fully possible to walk and chew gum at the same time. So let's just get going on it.
At times, people can do that. Thank you, Madame Shabat. But you are correct. The study does not conclude, and as soon as I have direction on that, I'll advise the committee. I hope to have some direction, clarification by Tuesday on that. So with that, if there's nothing further, we will go. Madame Vien, à vous la parole.
Ms. Vienne, you have the floor for 6 minutes. Thank you. Thank you very much, Mr. Chair, and good day, dear colleagues. Thank you for hearing me this morning. Every time we get to a new step in working through this Bill C-378, I'm happier because what we're looking for with this bill is a way to make workplaces far safer, put an end to harassment and violence in the workplace, and to ensure that everyone, employees and those who cease to be employed, are able to access their rights, given that indeed those who have ceased to be employed are the ones at issue with Bill C-378. We wish, of course, to ensure that those who have ceased to be employed, who have indeed since 2021, have 3 months. Thanks to the changes at 65. 3 months is, hardly anything, but it's worse than nothing. And I think that working together, we can ensure that we provide them with more time to make their complaints. Moreover, I have a stake in this, given that this is a bill that I myself put forward, 167, to the Quebec Assembly when I was working there, which had a considerable effect on labor relations, providing for 2 years for former employees to make their complaints. This has led to good results and finally gave former employees enough time to make their complaints. Mr. Ellie, Ms. Hong, thank you for being with us today, for taking some time out of your day to be with us. We'll need your help, even though this bill is unanimously supported by all political parties. We all wish to ensure that employees and former employees are safe and that their workplaces are improved. Let me begin by asking you to update us on what the situation is in workplaces, for example, in the public service, but also in the private sector under federal jurisdiction. What we can see is that, things are on the rise. The report on harassment, on violence that was tabled in 2022 does specify that, very unfortunately, there is more behavior of this type, more violence, more harassment, and the public service is not protected from this. In fact, it's one of the worst workplaces in this regard. So, Ms. Hong, perhaps I can ask you to begin.
Well, I would just like to note that you are correct. We have provided 2 annual reports thus far on the current status of the reporting, employer reporting from the perspective of harassment and violence in the workplace. So as you noted, in 2022 annual report, there is an observation, particularly in the increase of the actual occurrences that are reported and investigation of those in the workplace. So the report, we have observed 26% increase since the 2021. But what I do want to mention is that an increase in reporting occurrences may be attributed to a variety of factors, particularly employees in federally regulated workplaces, whether that be private or public federally regulated workplaces, are becoming more aware of their protections and of their rights. So, and as a result, they are subsequently reporting these instances more often and more frequently. So there is definitely a continued effort to prevent workplace harassment and violence and to support employees in all federally regulated sectors, both public and private.
Diriez-vous, Madame Hong, que le projet
Ms. Hung, in your opinion, do you think that Bill C-378, which we are considering today, will ensure that managers and business owners, because in C-65 there was a requirement to produce a corporate policy in this regard, but do you have the impression that the current C-378 will ensure that we will have a new tool to mobilize managers and business leaders to ensure that their workplaces are safer?
Monsieur Ali aussi,
Mr. Ali as well, you're welcome to answer.
Thank you. I will start by saying that the actual Bill C-65, which was the original bill that introduced the changes to harassment and violence prevention that we currently have in place, has significantly strengthened what we had in the past. And it has significant number of requirements on the employers, managers, and others in the workplace from the perspective of prevention of harassment and violence. So some of the elements will include a development of a policy that actually engages both employer as well as workplace committees and the employees, as well as requirement of a mandatory training for all, whether that be managers, supervisors, workers. So there are a significant number of changes that bill has introduced as well and that are currently in place. So I will say that the system is significantly more robust since 2021 than it has been in the past.
Merci, Madame Vien.
Thank you, Ms. Vienne.
Non, pas du tout. Il me reste combien de temps, Monsieur le Président?
How much time do I have left, Mr. Chair? Oh, it's over. All right.
30 seconds over.
I would like to keep going.
Mr. Fragas-Catos for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. And Ms. Vienne, if you have another question, you can go ahead. That's very kind of you, but go ahead. It's your time.
For being here today. I can say that, the proponent of the bill knows this, I'm quite supportive of the bill. I think it's a very reasonable measure, and our side does support it as well. Just a couple questions from me, and then if there's time remaining, I'll pass it to Mr. Long. First of all, how does this bill compare to other G7 countries or other democracies, if we want to be more broad, this move towards the 2-year threshold? Where are other comparable countries with an issue like this?
So thank you for the question. The way Canada Labour Code works with respect to, for example, U.S. labor laws, federal or state laws, or other G7 countries, I would say it's not apple-to-apples comparison. So that is one thing for us to consider. But a general comment would be given. We already have C-65, which is a very robust set of framework in this regard. We can safely say that Canada has a very strong framework to prevent and otherwise manage incidents of harassment and workplace violence.
Thank you. Under C-65, what is the threshold then? What is the time period in which a former public servant can make a complaint?
Thank you for the question. Right now, it's 3 months for the occurrence that can be reported by a former employee. Then there is 1 year time for the employer to figure that out, whether they can resolve it through informal discussions or the conciliation process or the investigation process. There are multiple ways for the employers to resolve. So 1 year is given to that. After that 1 year, the employee can again take another 3 months to make formal complaint if none of those, if they are not satisfied by the employer during that 1 year. So in total, I would say 18 months under the current law.
Okay. So, as you say, 18 months compared to 24 months. This, I think, with great respect, the bill that our colleague has put forward would, from the vantage point of a former civil servant, allow for more time and therefore would, on the face of it, seem more just. Is there, you're nodding your head, so you would agree, or?
So in addition to those 18 months, as I mentioned, there is another element to this C65, which is, so if we reach a stage, 18 months, the complaint has been lodged, and the employee is not satisfied at that stage, they can then take the matter to Canada, to Labor Canada, Labor Program, and there is a head of compliance and enforcement who can then grant additional time depending on the circumstances. So, for example, there was a discussion about 3 months are not sufficient time, and some of the victims could be going through some medical or psychological situations, and they have to take more time to recover from that. If they can prove that they are facing that type of situation, and they can mention that to the labor program head of compliance and enforcement, there is a provision that they can give them extension, and there is no limit to that.
But the private members bill that we are studying here would not prevent any of that from also happening.
That's
so
true.
It's not opposed to what you just described.
That's true.
Okay. Final question for me, and this does happen with, I suppose, any bill, whether it's initiated by the government or a private member. Are there unintended consequences that you've identified here that you think the committee should reflect upon? This is not uncommon with any piece of legislation, but I find in particular with private members' bills, there could be an unintended consequence. I haven't seen that. I've reflected on it a bit, but it would be good to hear from you on this, or to Ms. Hung, if she would speak.
So, maybe I'll start, and then I'll ask my colleague. So a few things. Number one is, as we increase the time in the law, and the message is then heard by employers, not only the public service, all the federally regulated employers who will be impacted because of this. They will have to adjust their HR regime in order to more record keeping, but also prepare for additional investigative work. So there is that requirement, and so there will be some incremental cost attached to that. We have not done proper calculation to that. We plan to do that as a result of the 5-year mandatory review that will be done to the C65 starting in January 2026. So we'll have a more wholesome idea about those impacts. Danielle?
Madame Shabbat.
Ms. Shabbat, you have 6 minutes. Thank you, Mr. Chair. Thank you to both our witnesses for taking the time to answer our questions here. As you can see, I think that we must once again thank the person who has sponsored this legislation. I think we unanimously agree around the table that allowing for this 2-month or 2-year time for former employees to make their complaints will, to our mind, strengthen the relevance of the measures that you brought in October of 2018. So that's not too long ago. Taken the long history of the Canadian Labour Code, your Bill C65. So this will strengthen, of course, it goes without saying, how much time a former employee will have to appropriately make their complaint. I understand from your earlier answer, and this does seem important, that there are already means in place to lengthen the amount of time that employee has to make their complaint if they demonstrate that, there is indeed good reason for the complaint that they're trying to lodge. They have the burden of proof in that regard. But often, if you're an employee, you're not even quite sure you're being harassed, that this counts as harassment. You have a problem. You may go for a medical diagnosis, be treated. You eventually might get to the point of taking time off from work. So I think it's very advantageous to ensure there's more time for all of this. Now, to our witnesses, I will put a broader question. I take it that you do oversee to some extent the enforcement of this framework. We had a witness from Quebec, of course, given that we are referring to Quebec and its legislation in labor relations. That this is a step forward, but that we could do better in offering reparations or corrections and other ways to support employees. Yes, we're going to allow them more time, but in and of itself, to put it differently, does our current framework suffice? Might we strengthen it, strengthen the legislation in place with certain other measures to really do better by victims, those subjected to harassment and violence? Do you, for example, ever make recommendations to the minister about what might be improved in the Canadian Labour Code in this regard, that of well-being and safety in the workplace?
Thank you for the question. So what I would like to mention is that as part of the Bill C-65, throughout the study process, there was a requirement added for a 5-year legislative review of all of the provisions that currently exist under Part 2 of the Canada Labour Code as well as the regulation. So 5-year review is almost there, and we are currently in the preparatory phases of that review. So we will be looking at the successes of the current regime as well as any opportunities for its improvement. So I would say that that is absolutely where we are headed in the coming years.
Est-ce qu'il y a un mécanisme de consultation?
Is there a means to ensure consultation of employees and employers in the 5-year review plan, for example?
As mentioned, we are currently planning for the review, but absolutely as part of all of our reviews, we consult with our stakeholders. That is through tripartite engagement. So we do engage with employers and employees, and we actually engage with them on a regular basis through our advisory committees. So they currently have an opportunity to provide this feedback, but we will have a more formal process for that at the 5-year review stage.
Peut-être une dernière question, Monsieur le Président.
Thank you. Thank you. Do I have time for a final question, Mr. Chair? Indeed. All right. So I think it's quite clear that this bill will get through our committee. Have you any statistics regarding complaints that have been thrown out because they've run through their time? If we allow for more time, from 3 to 12 months, or 2 years, 3 months to 2 years, rather. So going from 3 months to 2 years, then fewer complaints will be thrown out. Do we have any statistics about those that have not been carried through on up till now due to the fact that they're overtime?
Et pensez-vous que ça va...
Moreover, do you think that what we're bringing in here will improve matters?
I can provide you with a little bit of statistics that we do have from the perspective of your question. I can say that we have, since January 2021, received 6 complaints from individuals that did not, that were outside of the 3 months period. So 6 complaints were received. In the majority of those cases, individuals did not proceed to seek any extension. So it was total of 6, and in one case, an individual has requested extension of time, but were not able to demonstrate that they meet the requirements of the legislation in order for that extension to be granted.
Madame Chabot, committee members, I see the light, the bells may be ringing. Do we continue until we figure it out? Is it okay? Okay. Yeah. Oh, okay. Oh. 30 minutes. So what is the wish of the committee? Does the committee,
House for the vote, please.
at the moment?
Yeah.
Okay. Well, no, Madame Zarillo has requested that she wants to depart, so with that, I'll have to suspend. I have to suspend the meeting until the conclusion of the vote. The meeting is suspended until the conclusion of the vote. Suspend. The committee has now resumed, and we've resumed with the agenda from the first hour, and we're about to proceed to Madame Zarillo for her 6-minute questioning.
Thank you so much, Mr. Chair, and thank you for the ability for me to go back into the House for my vote. We were discussing a very important piece of business, women's reproductive rights, and unfortunately the Conservatives decided to try to adjourn that debate and to stop the debate on women's reproductive rights. So, of course, as a woman and a supporter of women and people of diverse genders, I definitely wanted to be there to stand on guard against the regressive Conservatives' pushback on women's reproductive rights. So we have here some testimony that was received from Nicholas Thompson in regards to.
Specifically go to the order you're referencing.
Thank you, Mr. Chair. Just in reference to adjectives that are defamatory to people, I don't think are appropriate, and also just to put on record that in fact today is a Conservative opposition day in the House, and
that is not that's debate, Ms. Gray. Madame Zarillo, you have the floor.
Thank you so much. So, yes, Nicholas Thompson brought testimony to this committee about the lack of justice and accountability, and we know that Nicholas Thompson is leading a human rights complaint against the federal government right now in regards to harassment. So there was 3 recommendations, 3 areas: disciplinary action, restorative outcomes, and supports for employees that this witness referenced when they came to our committee. And I'm interested to know how these can be placed or if these have been discussed internally. So on disciplinary action, Nicholas Thompson brought up investigations that confirm harassment or violence should automatically trigger a referral to a disciplinary body. So I'm interested in your opinion on that. The second one is on restorative outcomes, that the process should include provisions for financial compensation, public acknowledgement of wrongdoing or apologies, which it does not provide at the moment. So I'm interested in your thoughts and opinions about having that included. And supports for employees to strengthen support for marginalized workers with specific programs that would be developed to address unique barriers faced by Black, Indigenous, and racialized employees. And it goes on to say in the recommendation to include culturally relevant training, outreach, and tailored assistance to ensure equitable access to the complaint process. So this is just around justice and accountability. If you can share your thoughts on those 3 potential inclusions.
Thank you. Thank you for the question. So I will just maybe mention a couple of elements, as I've already indicated earlier. I do want to mention from the perspective of support for employees, maybe I will start there. The employers, part of this actual regime that was introduced in 2021 as part of the Bill C-65 was actually supports for employees. So one of the elements was really focused on supports. So as part of the process, employers are required to provide any information to all employees on what supports are available to them, whether that in the workplace or other supports that may be available. So the regime is about prevention, prevent, respond, support. So there is that element that currently exists in the actual provision. I will then mention from the perspective of disciplinary actions, I would like to mention that that element was discussed as part of the introduction of Bill C-65. And the decision was at the time made that it is the discipline is part of, can be outlined in the actual harassment and violence prevention policy. So those are the elements that employer is obligated to develop a policy in the workplace with respect to harassment and violence prevention, and element of discipline can be outlined in that policy. So those are some of the elements that I wanted to raise. I think my colleague will add another element.
Thank you, Ms. Hong. So I can also add that, especially the discipline angle is that, so the employer has their policy about the prevention of harassment and violence, and in that they would have those measures covered. And when suppose there is an occurrence that happens, and there's a complaint process that is being pursued, as a result of that, there is an investigation happening, and whatever comes out of that, it becomes employer's responsibility. So suppose it is established that this has happened, violence or harassment has happened, becomes incumbent on the employer to take necessary actions according to their policy, and then if there is a discipline angle captured over there, they enforce that. In parallel,
Is there an external body, like the witness was saying, if it's been assured that this is what it is, can it go off to another body, an external body?
So we have Canadian Human Rights Commission route. They can also go to police. It's in the law. And then if all those things, we also have labor program. So if they are not satisfied, they can come to the labor program and complain and go through that. So the multiple avenues are available.
Thank you, Ms. Cirillo. That concludes your 6 minutes. I've had a discussion with the committee members, and there is agreement. I'll seek your opinion as well, Madame Cirillo, on that. We will proceed at this stage to clause by clause. Do we have consensus in the committee to proceed to clause by clause? Madame Cirillo and Madame Chabot. Okay, the witnesses will stay, and we'll be joined by the Legislative Council. So thank you, Member. Pursuant to the order of reference of Wednesday, September 25th, 2024, the committee is commencing its clause-by-clause consideration of Bill C-378, an act amending the Canada Labour Code, complaints by former employees. The officials from the Department of Employment and Social Development are present in case members have questions. Clause-by-clause consideration of Bill C-378. I would like to provide members of the committee with a few comments on how the committee will proceed with clause-by-clause consideration. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. Although no amendments were submitted in advance to the clerk, members may propose amendments and sub-amendments from the floor to the clause in question, provided they are submitted in writing. If a member wishes to move an amendment or a sub-amendment, I will recognize the member willing to move it who may explain it. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. In addition to having to be properly drafted in a legal sense, amendments must also be procedurally admissible. Since there was no amendments made here, that would only be dealt with procedurally if amendments are received from the floor. During debate on an amendment, members are permitted to move sub-amendments. Approval from the mover of the amendment is not required. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will vote on the title and the bill itself. The committee will have to order the chair to report the bill to the House. That report contains only the text of any adopted amendments as well as an indication of any deleted clauses. Finally, if members have any questions regarding the procedural admissibility of amendments, the legislative clerks to my right are here to assist the committee. However, they are not legal drafters. Should members require assistance with drafting an amendment or a sub-amendment, they must contact the Legislative Council. I thank the members for your attention and wish you all, we'll not finish that one. Okay, here are we at. We're in the clause, clause 1. Okay, we do have before you, so we'll now, shall clause 1 carry? Discussion? Seeing none? I have to vote.
You don't, they have to vote, but it doesn't have to be a recorded vote. It's up to
Okay, since it's only 4, I'm going to ask for a recorded vote on each of the clauses. Recorded vote on clause 1 as presented.
Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Coteau? Mr. Van Bynen?
Yes.
Mrs. Gray?
Yes.
Madame Vien?
Oui.
Mr. Lippert?
Yes.
Mr. Aitchison?
Oui.
Madame Chabot?
Oui.
Ms. Zorillo?
Yes.
Yeas pour 11-11, nays contre 0. Okay.
Clause 1 is carried. Shall clause 2 carry? Seeing no discussion, Madam Clerk, recorded vote on clause 2.
Mr. Fragiscatos?
Yes.
Mr. Long?
Yes.
Mr. Collins?
Yes.
Mr. Coteau? Mr. Van Bynen?
Yes.
Mrs. Gray?
Yes.
Madame Vien?
Oui.
Mr. Lippert?
Yes.
Mr. Aitchison?
Oui.
Madame Chabot?
Oui.
Ms. Zorillo?
Yes.
Yeas pour 11-11, nays contre 0, aucun.
Clause 2 is carried. Shall the title carry? Recorded vote on, do we need to record a vote on the title? Don't think. No. Shall the title carry? Merci, madame.
Somebody had to say no.
Yes.
Yes, okay. The title is carried. Shall the bill carry? Yes, thank you. The bill is carried. Shall the chair report the bill to the House? Agreed? Thank you. This, you were right, Madame, or Monsieur and Madame Legislative Attendant. I have one final piece here. As you know, it has been my prerogative style as chair is to allow those members that bring motions or bills to the committee to, if they choose to, present them in the House. With that, then I need a formal move. Is it agreed that Dominique Vien present to the House the report on Bill C-378, an act amending the Canada Labour Code, complaints by former employees?
Yep.
Good. Good, Madame. Thank you. With that, the meeting will, Madame Zorillo?
The committee, any dissenting or supplementaries? What's the process? Sorry, I wasn't.
Yeah.
Madame Zorillo?
Because it's legislation, there's no dissenting.
It's legislation.
Okay,
There's no
so there's
dissenting
none?
reports.
Okay,
No.
just wanted clarity.
Oh, thank you for that. Yeah, but it's legislation. The committee will meet on Tuesday, December the 10th. With that, is it the will of the committee to adjourn? Committee adjourned. Thank you.